Dear friends, the Supreme Court of India on last Wednesday has granted an interim relief to Assago University Professor Ali Khan Mahmudabad but declined to stay the ongoing investigation into his social media posts related to Operation Sindhu. It is highly shocking and deplorable. Why for and what for is that Ashoka University's professor media posts do not breach the Constitution's narrowly defined limits on free speech. This video explains the reasons thereof. The Frontline magazine has rightly criticized this in these words. I quote, "What Justice Khan's bench has failed to do is even more revealing. It didn't interrogate the political motivations behind the complaint. It didn't test the FIRs against the established free speech jurisprudence. It didn't use whether an academic post, no matter how critical, could legitimately trigger criminal prosecution under any constitutional standards. What is the settled legal position in this matter is this. The Supreme Court's Shreya Singha judgment, which clearly held that mere annoyance, inconvenience, or the causing of offence cannot form the basis of criminalizing speech. Expressions that offend, shock, or disturb are constitutionally protected under Article 19(1)(a) within reasonable restriction. Justice Khan's bench has denied, that is, the freedom of speech and expression as enshrined in the Indian Constitution and also been guaranteed in the Universal Declaration of Human Rights and UN Charter under Article 19 of the UDHR. The Deccan Chronicle newspaper in its editorial on 23rd of this month has rightly pointed out that the mandate of Article 19 have no constraints of timing or subject, save protesting those mentioned in the Constitution itself. As the NHRC, National Human Rights Commission, rightly pointed out that the arrest and incarceration of a citizen for expressing his opinion was prima facie a violation of human rights and liberty. Finally, through this video, what you want to tell to the Supreme Court of India is this: courts exist to protect those sacred rights, not to endanger them. In the legally settled matters in the past, the citizens' rights to speech and expression have been guaranteed under the Indian Constitution and various legal settled positions, so that the freedom of speech and expression is the basic fundamental right. It is an inalienable right. The Supreme Court of India must squash the FIRs that have been filed against the professor of Ashoka University in the larger interest of saving the democratic values and constitutional ethos as mentioned in the Indian Constitution, and the voice of dissent must be honored and adhered as per the Constitution of the country. Thank you so much.